Up 2 o'clock, so we're going to get started. Um, Thank you so much for joining Health Agents for America, our Hoffa Education Thursday. It's something that we try to do as much as we can to make sure that you're educated on all the issues. This was a presentation that was done last week, and we've gotten so many rave reviews, so many questions, so many I need more. We decided to invite Alexander to speak again. I am Ronell Nolan. I might have said that delirious, but President Health Agents for America. The beginning of the presentation you saw, or you can see now, our legislative team who is headed to Washington, D.C. to fight for agents and brokers and involved on every aspect of the things that you need. I'd like to tell you a little bit about Alexander Liebergall. He is the Director of Compliance for Concepts Incorporated and one of our HAFA Presidential Board members. I'm very honored that he works with HAFA, and it's exciting to have him as part of our team. He is an experienced compliance director with a demonstrated history of working in the health care and health insurance industry, skilled in legal analysis, policy development, and implementation, regulatory analysis, management, leadership, and public speaking. And I do have to say, he is an amazing public speaker. So thank you so much for joining us today. I'm going to turn it over to Alexander, and he will be able to share his screen. And thank you so much, Alex.
Thank you, Renell. Can everybody hear me okay? Okay. So, happy to be back to follow up on the session from last week. So, what my plan is, some of you may have been here last week, some may have not. So, I was going to take the first maybe 10, 15 minutes to go over at a high level the key topics that were covered last week. And then I was going to go over the variety of questions that we didn't have time to go over last time with my responses. And then if there are any additional questions, happy to try to address those. And then if we have even more time left, then I can go back and cover the other parts of the rule that we didn't get to talk about at all last week. So, but regardless, if we don't get to that, they're covered in the deck. So I'm going to share my screen. Can everybody see? Okay. All right. So, as I mentioned last week, this presentation discussion was primarily focused on the fifth item out of the list of items that this new rule is seeking to address and potentially change. And that fifth item was related to agents, brokers, and web brokers, and proposed changes for standards of conduct and marketing enforcement. And this piece can also be broken down into five distinct items, like we discussed last week. So, first one is structural change, and it's a split in enrollment conduct versus marketing conduct. It's a physical change to the regulations as they exist today, because they are proposing adding an entire new section and shifting the way that things are written currently. And specifically, what they're doing is they're proposing to separate conduct that's related to consumer enrollment from and make it distinct from conduct that's related strictly to marketing. And this allows them to create this new section and expand and implement, specific marketing rules and prohibitions that they didn't have in the past. And it matters because this means that it's more than just general misleading language, right? They're going to they intend, at least they propose, right, to have enumerated prohibitions. And this will allow them also to support uniform enforcement, sorry, because there are much fewer gray areas in an environment where you have a defined set of rules and defined prohibitions. It's black and white if they catch you engaging in that type of behavior. It's a simple way to think about it. So the second item is changes to enrollment standards of conduct, right? So the existing rules as it relates today. So as everybody, is aware, and if you've been in the industry, whether it's been a long time or just the last few years, you, I'm sure, know and have probably personally been exposed to with your own book, fraudsters and bad actors and them, misusing client PII, doing enrollments without authorization. And one thing HHS has done is link marketing issues and marketing enforcement to that. And I don't think they're necessarily entirely wrong. I mean, I can give you one great example of conduct that is definitely prohibited, but that was widespread, is an online form where you fill out your information, which is, I mean, a typical standard lead form. There were bad actors that were then taking that information and directly using it to complete an enrollment without the knowledge of the clients and the consumers. It's a great example of fraud and PII misuse from marketing directly causing the types of fraud that they are trying to eliminate and have been trying to actively eliminate. So that's one of the pieces this tries to address. So specifically, the first thing that they had proposed that relates to this is an HHS approved application an form, right? So right now, for anybody that has taken the FFM cert, you know that CMS has a template that you can technically use, right? But it is not mandatory. And what they're proposing here would basically make it mandatory. And it would require that two pieces be met. The first is the consumer consent documentation. So ensuring, you have their consent up front before you access their eligibility app and make changes to their accounts, etc., right? And then the second is the eligibility application review documentation requirement. And specifically, what that is the part where you're ensuring that the clients understand the attestations that they're agreeing to or that an agent is agreeing to on their behalf, that the information they provided is in fact accurate. And essentially, if you think about it simply, it's about the client confirming that they understand what's in the app and the consequences of providing misleading information. So there's those two pieces. And the other piece that relates to that is defining what an action means, right? So they're proposing to codify what counts as a consumer action that is sufficient to prove, one, that the consumer reviewed the application, like we just discussed, and that the consumer provided consent. And they give acceptable options and they give non-acceptable options, though granted those are a little bit vaguer in my opinion. So when it comes to things that are acceptable, standard things you would think, right? Handwritten signatures or initials on that consent form, that model form and document that they're talking about, electronic written signatures or initials. Now, that can be a little bit more complicated depending how you dive into it, only because when it comes to e-signatures, there's a law called the Federal E-Sign Act that dictates, what is generally a sufficient e-signature or not. And there's certain things that, you need to make sure that you're in compliance with in order for it to be a valid electronic signature. I mean, but that's a separate topic. And similarly, right, has to be directly on the document itself. It can't just be a random signature on a completely unrelated page or form. And they also would accept an email from the consumer or their authorized rep, basically providing and agreeing to the stuff on the consent form, a recorded conversation, which is in line with the practices today, right? So if you have a call recording between yourself and the client and you go over all that information as if the form was in front of them and you were showing it to them in person, that would be sufficient. And then they leave this, catch-all, unsurprisingly, of other clear or verifiable means. And that's actually kind of a good transition to the opposite, which is the examples that they're not wanting and things that they will not accept. So it comes down to basically whether or not HHS can verify who did it. If they can't verify who was the person that sent or provided that consent, right? Whether it was sending the email, whether it was doing an e-signature, whether it was a physical wet signature, right? Then it would not meet this requirement they're proposing of an action that provides sufficient consent on both parts. And the one example they do give in there, well, technically it's two, is a signature that's simply like typed into the documentation or a filled in checkbox. Admittingly, I think, an argument can be made that typing in your name could actually satisfy the e-sign requirement. There's a lot of things that are involved in there. So I think this piece will likely require a little bit more hashing out before the rule gets finalized, but we'll ultimately kind of see where that goes. But at the end of the day, what they're looking for is a cleaner evidentiary record so they can have and prove who did what and when. And in reality, this would help support faster investigations and hopefully removals of misleading marketing, removals of agents and agencies that are engaging in bad practices, and help, continue to curb the conduct that they're concerned with. So the third one is the creation of the explicit rules related to marketing that I mentioned earlier. So it's really can be broken down into two pieces. So the first piece is effectively the creation of like a general baseline standard. And under this general baseline standard, there's really two pieces to think about, which in reality, if you ask me, is something that I think is implicit and, it should exist in the insurance industry as is, just my personal opinion, right? So the first one is ensuring that any marketing provides correct information and does not omit material facts. And the second is that it's not misleading, it's not materially inaccurate, it's not coercive, and it's not discriminatory. All I think makes sense. Then the second piece is the 7 specific examples that they want to codify as prohibited misleading marketing practices. The first is cash and cash equivalent inducements, right? So prohibiting the ability to provide inducements to clients to get them to enroll into plans. Effectively implementing gift limitations that mimic the existing rules under Medicare, which is $15 per, I want to say transaction, but let's just say transaction, or $75 aggregate per year per person. And for people that, do like not endorsements, that do raffles, giveaways, uh, give little like tchotchkes away, like the kind of stuff that you see, for those of you that have gone to conferences, pens, the little like stress squeezy things. If you do any of that kind of stuff, you have to start tracking how much it cost, who took what the value was, because if CMS were to come knocking because they find out, somebody reports that they were given something of higher value, you're going to want to make sure you can produce records that either say that they're wrong or that support that you were following the rules. Then the third one is eliminating, marketing that says things such as everyone gets a $0 plan or you will always qualify for a $0 plan or everybody qualifies for a $0 plan. For those that sell Medicare, I mean, this is very similar to like the absolute language standard that you have today. Unless you can substantiate a claim, you should not be using it to market what you can offer. So it makes sense. Next one is the no official uh, lookalike documents, right? So things that use color schemes that are similar to CMS, logos that are similar to CMS or HHS or healthcare.gov, right? You can't create or use materials that have that look and feel of being official from the government or from healthcare.gov, right? Because they're not. And then no misrepresenting enrollment timelines and deadlines, unless it's so that the classic one with that is like high pressure tactics, saying like you have to enroll today or you're not going to be able to enroll again. You have to enroll tomorrow. You only have 2 days left, right? Things like that to get people to pressure them into conducting an enrollment when in reality they do actually have more time. You see that, I think, honestly, a lot during, not a lot, but probably more than minimal during OEP, especially towards the end, and likely happens with SCPs as well. Next one is no fake or misleading legal citations, and that relates to things such as them inventing that a new law was created and that you need to sign up for coverage now. I actually personally myself got a phone call not that long ago that told me that a new federal law was passed and that I needed to sign up today to get my, I forget what they said. I think it was like $5,000 cash card, or I would lose the ability to do that. A lot of stuff wrong with that automated message, right? But that's an example of this specific use case. Then the last one, very similar to what we have on Medicare currently, which is no false celebrity petition or politician endorsements. Now, if they are legitimate, right, then theoretically they could be used, right? But they're also concerned about deep fakes and effectively trying to use someone who's prominent or famous to help convince somebody to buy a plan when in reality they have, there was no endorsement, it's not real, and it can trick people. Fourth one is the marketing enforcement. And this one can also be broken down into kind of two primary pieces. The first one is the duty to produce marketing materials upon request. So if you get audited, if they're doing monitoring or if you have their enforcement action, they're effectively creating the requirement that if they come with you to this with these requests, you have an obligation to be able to produce any pertinent materials. And the scope of what their requests can be are not necessarily clearly limited. In theory, they could ask you to produce every marketing material that you've used to generate FFM enrollments. Now, would they do that? I don't know, right? Because that could be a pretty big volume, and just like everybody else, and CMS only has so much staffing and so much personnel. So the second piece then is you owning your own downstream. And realistically, that language refers to lead generators, downline agencies, vendors, sub-agents. And effectively what they're proposing is that the agent, broker, web broker, that they are responsible for ensuring that marketing that's created by the individual or entity on their behalf complies with the requirements. Pretty straightforward, honestly. The biggest change I think there is this now becomes a more formal requirement, and this is not necessarily incredibly easy to do, right? And it just will take time and effort, honestly. And this is where ensuring you have good contractual protections, that there's proper oversight in place, helps shore this one up for you. And the last one is enforcement pathways and the mechanisms that they intend to use to go after entities and individuals that don't follow these rules. So the two ways specifically is what's called technical assistance, or TA, and the standard termination process that they have the right to implement under existing rules. So they want to use first technical assistance to address misleading marketing. And they propose that under the technical assistance approach, it'll basically require and follow two things. So the first is the removal of misleading marketing material, which is a reasonable request, right? And then requiring review of CMS provided compliant marketing materials. Makes sense. Very standard, right? I don't think it's anything that if you're a good actor, you would be concerned about. And what's the one thing that is nice, right, is with the first one, they're giving you the opportunity to correct it. If unfortunately you end up in a situation where you were misled by the entity or individual that's marketing for you or helping generate leads and calls and clients. They give you the opportunity to take that down, correct it, and hopefully not proceed any further, which generally would be termination, right? However, they still say that they reserve the right in some cases to terminate exchange agreements for cause violations and use the standard process they have in place, which is the 30-day notice and opportunity to cure. And after that, the reconsideration process once termination happens. And it's important because as a result of all this, marketing noncompliance can now become a direct pathway to losing your ability to assist with enrollment, financial assistance, all of that, right? Through the FFM, because you could lose your certification. So that is the review of the items at a high level from last time. So now I'm going to jump into some questions. So I'm not going to mention the names of the people who asked the questions because I don't know if they're here or not. So I'll simply just go over the questions and then my answers, and then any additional questions we can then jump into. So the first, this question actually came up from a couple different people, which was regarding whether phone calls would still be acceptable under the proposed rule as a mechanism to obtain consent. And the answer is, so to the question is no, right? They would still be acceptable. And they explicitly say that recorded calls would be sufficient, just like they are today. But ultimately, right, it comes down to them containing the sufficient elements to evidence that all the requirements were met. Next question we had is someone had brought up, oh wait, actually it's the same one. Yeah, so frequency of documentation needed. So specifically, this individual asked that if a client requests that an agent update something on their application several times a year, is there still that obligation to do so? And I mean, for what I've seen in the rules, I mean, there's nothing that necessarily changes that from a, relationship perspective. I mean, I would think it still makes sense to make sure you're servicing your clients. And ultimately, if something does change, like income, you don't want to be in a position where the client tells you about it, you don't take any action on it at all, including not telling them, that they can do it themselves. And then at the end of the year, or the following year, I should say, they now owe money, right? And that piece will actually become even more important because one of the pieces of the rule that they're proposing is effectively eliminating the caps that exist today so that regardless of your income level, if you were given subsidy that you didn't qualify for, you have to pay it back. So it has a real impact. So next question was regarding cash equivalent inducements, and specifically whether or not it will cause some carriers to get rid of the wellness rewards programs that they have today. And it's a great question. In my opinion, the way that the rule is written and who it's targeting, I don't think that that's going to happen. It doesn't mean that it's not, right? I could see carriers prohibiting the advertising of those programs up front because it is still a big problem today with bad actors luring clients in using that. But ultimately, it's not illegal or prohibited for them to offer that program in general. So I don't think it's going to get impacted. But I mean, if you have carriers that want to take a super conservative approach and eliminate that risk entirely, it's possible that they get rid of it, but it's not something required under the rule. So someone had asked for an example of a technical assistance letter. I know, Ronell, you had commented that you would see if you had one that you can share. I don't know if you had a chance to grab that, but I did
Oh,
have
good.
a redacted one I can show you. Now, granted, this is a little bit different because it obviously doesn't cover the marketing pieces because that's not yet in effect, but it kind of gives you an idea of the general uh, structure here. So give me 1 second. Can you guys see the letter in front of me?
Yes.
Okay. So for those of you that may have received the letter or investigation from CMS in the past, it is very generic, right? And from what I understand, this letter actually is an example, was sent to a bunch of people around the same time in the beginning of the month. And what's interesting is in this letter, right? So you have this first piece here. They don't give you any specifics. Like they don't tell you specific consumers that were involved. They don't give you dates. They really don't give you anything to actually investigate it to see if it's actually occurring, right? It's just a general notice with what they call helpful reminders, which are things that obviously, as a certified agent broker, or a broker, you should be doing already. And that's it. Now, the technical assistance letters in the form that they're talking about as it relates to marketing, I would imagine would have more specific action items than the form they have today. But at the end of the day, it's still likely going to be like this generic letter template that asks you to provide documentation. As simple as that.
Yeah, Alex, I did get one of these. And there's no information. They didn't tell me why. I barely have any clients, so I don't even know what they're talking about. But in the email, it did say that they reserved the right to take my certification. Now, no reason, no person, no timeline, no anything. And I did talk to CMS and I said, you actually sent this to the wrong person. And they're like, well, we have to go after the CEOs just like everybody else. I said, no, you went after a bulldog, and I don't appreciate this when I don't even know why you have a problem with me. So we definitely need to push back.
I completely agree. I'm curious, I think what they will look like when they first start to come out related to this, assuming that the rule passes with all this in it. I would hope that it would be a little bit more specific. So, next question I had is somebody actually had asked if there were some examples that I could share of ads that were misleading. And there are actually three. And for those of you who are contracted with a particular carrier, you probably would have already seen these in the past because they were part of a notice and document that this one carrier has shared many times. So, okay. Can you guys see the ads? Okay. So there's three. So the first one is presenting the government subsidy as a benefit card. I mean, and literally, right? It says benefit card. It looks like a cash debit card, has gas, rent, groceries. Very misleading, right? So this is the classic example of things that were seen within the last couple years that they're trying to specifically curb. The next one is a little bit different, but substantially the same thing, right? For this one, they're specifically saying that you can earn $500 in healthy rewards. And again, presenting it as a debit slash cash card. And the one thing that is super important when it comes to this ad, you can make an argument it's not as bad as this one up here, right? But it's still problematic because for a lot of these programs that provide you that cash benefit or that, rewards card, you have to do certain things, right? Such as like, set up an appointment to your PCP, actually take some sort of action. You don't just get the card and get the money generally because you sign up for a plan. But that's how it was being marketed. And the last one was this example, right? Again, my health rewards, and they presented, I actually use a Visa logo, which is crazy to me and probably a copyright issue in general. But this is obviously problematic because it's the same thing. And that's the big trend that they're trying to address. And you can see that through the regulations because they're specifically trying to put in a prohibition on this direct type of marketing. So the next one was, will CMS tie a broker to a consumer who should be enrolled to ACA but was enrolled to short term as a marketing or enrollment conduct problem? It's a great question. And honestly, I don't know. And I don't know that the answer is necessarily clear because it's going to depend, right? You know, short terms now are a viable option for people who can't afford ACA. I mean, there is a subset of the population, right? Typically the people that are healthy, don't have pre-existing conditions, that a 12-month short term or even longer, right, is a better option than paying full premium on a individual marketplace plan. So that's really going to become, I think, a bigger factor. But I do say and do believe ultimately, if short-term coverage was not appropriate, which is an issue we saw, you know, years ago before the 150% SEP and the previous administration's reductions for short terms, right? Was people marketing them as comprehensive coverage, right? Marketing them as ACA compliant coverage, not communicating that there were exclusions, that pre-existing conditions had waiting periods, were not covered at all, right? Stuff like that, I think, would still obviously be problematic. Now, whether or not CMS has the authority to act upon that, I think is a different question. I mean, technically, right, they don't regulate short terms directly themselves. It's a state issue. And typically, when I've seen that type of conduct happening, it's the state DOIs that are really the ones that take action. And in reality, I don't think I necessarily see that changing. Of course, CMS can work hand in hand with the DOIs, but it was a good question. So ultimately, we'll have to see kind of how that pans out. So the next one, someone actually had suggested, Ronell, right, that we consider saying to CMS that they need to send to the consumer via email a copy of their enrollment, and that the consumer needs to then consent to the information to have that application submitted, taking theoretically, right, the agent out of the whole loop and concept of having to provide proof themselves. I understand where that comes from, but I will say I think you have to be very careful with requiring something like that. There's a variety of different problems, but honestly, like a simple fundamental one, not everybody still has email, right? For people that live in low income communities, impoverished areas, there are still plenty of people that don't have smartphones or computers or have email access, or even if they have email, actually use it. So you wouldn't want to implement a process, and then this is why I really don't think CMS would do it, where you're inadvertently discriminating against these people, right, who by their nature are generally considered a vulnerable population. You don't want to create another barrier for enrollment, right? Because if you do that, you're then theoretically creating a new barrier for them to get health care, which is already a problem in a lot of these communities, unfortunately. So the next one, someone had specifically asked about the typed signature and whether or not that was acceptable, and asking if they would follow their own rule. I think they mean CMS, and specifically noted that you must use a typed signature on all eligibility applications through CMS currently. So at the end of the day, I think regardless of how they try to approach or enforce what's a compliant action, if they're trying to say something is or isn't a valid e-signature, I mean, I think ultimately that comes down to probably somebody challenging that, because at the end of the day, there is a law, the Federal E-Sign Act, right, that clearly and unequivocally establishes what is considered generally a legally valid e-signature. And if they try to be overly restrictive, then I think there will be pushback. There will be people that will sue, and I wouldn't be surprised if that part would get overturned. And considering recent experience with court stays and their rules, I don't know that it's something they would be inclined, or at least you would think it's they wouldn't be inclined to create this extra vulnerability.
Well, Alex, do you think that like you can sign something on a tab, not wet, but it kind of is. Would you think that that would be a wet, or would you think that it'd have to be ink on paper?
I consider wet very conservatively, which is ink on paper. What you're saying technically is an e-signature, and ultimately all you really need, arguably, I should say, is some specific identifiers tying the person to that signature. And actually, even using the example that this person brought up, right, about typing in your name as a signature on the eligibility apps or using a typed signature, as an agent, you would have already logged in to your account. So you have already identified that you are X person, right? And by doing that, that kind of meets the identity threshold, arguably, that you are the person who is typing the name in, right? Compare that versus, just randomly sending somebody a link and them just randomly typing in their name as a signature. If you don't get information like IP address, right? Or you don't require them to log into like their account or something of the sort, then yeah, I mean, they could probably argue that you can't prove who this individual was. And so I can understand that being not verifiable. But I mean, in reality, I don't think it fundamentally changes practice today if you're properly obtaining e-signatures. And I think I actually saw a couple questions come in about that, so I'm just going to take a look. Okay, so I'll come back to this. So the next question, and actually this ends up being in a couple different questions. They brought up an issue that I think is really important, which is now they brought up in the Medicare context, which obviously is a little bit different, but I think at its core is the same thing, which is that ads on TV, as an example, that are misleading or inaccurate. And concerns about, good brokers and agents, right, not engaging in misleading conduct, being disadvantaged, but compared with people that are engaging in misleading conduct, right? I think what's problematic is many of these ads that, especially with like this individual said that we saw on the Medicare side, are tied to big companies. And I think they continue to be questionable and, you know, who's approving them and how are they still getting there. At the end of the day, you'll never have 100% of things eliminated, right? There's always going to be at least someone who's willing to still do this. And it really just fundamentally requires the industry to self-regulate, right? Because the alternative is to have regulators come in, whether it's CMS, the FCC, the FTC, or, God forbid, CMS giving DOIs greater authority to enforce actions related to FFM and ACA. None of that will be good for us as an industry. And ultimately, we have to self-regulate and we have to get to a position where the majority of people in the industry are not using and not willing to support these types of ads and the types of companies that are doing those ads. Because at the end of the day, I mean, just to be practical, for as long as people are going to pay companies for leads that are driven through those ads, they're not going to stop. They're always going to exist in some form, unfortunately. So, similar kind of topic, shifting to telemarketing organizations in particular. So, the question, and I think I saw Stacy Smith asked a similar question. So, and actually, this is her question from last time. So, specifically was asked, why do there seem to be different marketing rules for telemarketing organizations versus local agents? Telemarketing companies actively harassing her customers during OEP. I mean, really all of our customers during OEP to get them to switch plans, telling them that they missed out on $2,000 of help with groceries and utilities that they don't qualify for, things like that, right? So fundamentally, there aren't necessarily separate rules. So it ultimately depends what the telemarketing organization looks like. If it's a licensed agency, right? It's FFM, the individual, the principal, the agents are FFM certified. CMS can absolutely have oversight over them, right? And in fact, the rules that they're trying to put in place reiterate that. The problem is, and I think that's really more what her question was getting at, was telemarketers and call centers that don't sell and are not certified themselves, right? So traditional lead generators, performance marketers, and I think it's safe to say the most problematic ones, unfortunately, are the ones that are located outside of the United States. So for the ones that located outside of the United States, the U.S. has no authority over them. And trying to pursue those companies in a lot of these foreign countries, right? Typically, the biggest ones you see that I've encountered in India, Pakistan, Philippines, Egypt, places like that, right? I mean, there are shops that get shut down on February 5th, open up on February 7th with a completely different name, same exact practices, same exact fraud. CMS can't do anything about that, right? They have no regulatory authority over them. Even the US based call centers, right? CMS's authority over us as agents and agencies, principals, sub agents, right? Because you're certified to sell. And the law says that if they grant you the ability to do that, right, they also can take it away and they can do enforcement. Well, without that, they have no authority over these call centers. Now, a few years ago, they did try to team up with, I want to say, I believe it was the FTC, and the FTC sent out letters to a large number, not a large number, but a number of the very large uh, lead generation companies and performance marketers, kind of threatening them, right, to say that you can engage in this type of behavior, and that if you do, we can pursue action against you. Having said that, I'm not aware of any substantial action that really came from that. And that's kind of going to be the ongoing problem and goes back to what I said before, right? It's self-regulation. Because if you think about it a different way, right? Those same people that are placing these calls about health insurance are probably the same companies placing calls about loans, car warranties, right? The fraudulent part of it, at least. CMS has no authority over them there, right? And I mean, technically, they're not licensed, they're not contracted. They can't just take enforcement actions against them. Next question was related to when would this go into effect? So it's a great question. So right now, there's no specific proposed effective date or applicability date that I could clearly find specifically related to marketing, misleading marketing provisions and changes, right? However, having said that, in the section where CMS summarizes the changes, they, and adding the new section, they mention that they intend to start to use these technical assistance letters and such in 2027. So maybe that is a sign that it won't go into effect until the start of plan year 27, right? So OEP next year, or actually waiting until 1/1/2027. Honestly, there's no way to know for sure. But I think it's important because, if you contrast that with other rules that they're proposing, some other rules specifically say that it's going to be applicable 1/1/2027. But if they don't say at all what the applicability date is or what the effective date is, then generally, right, they would take effect on the effective date that the rule is finalized. I mean, we'll find out ultimately, but it's a great question and it's something that I did, that caught my eye that they didn't actually say when they intended for it to go out. Next question was about carriers sending agents boxes of swag to give away at community events and whether that would still be allowed. It's a great question. Um, I'm definitely curious to see how it plays out. I think you'll probably see an overall reduction in the stuff that carriers send for these purposes because CMS intends to impose the same limitations that they have under Medicare, right? But again, I don't think you're going to necessarily see or have to see a decrease in like the tchotchke type stuff, right? Pens, the little stress squeezy things, uh, koozies, right? You see tons of those. All those types of little things can very easily fall under that $15 per, you know, gift, quote unquote, and $75 aggregate in total. So that I think covers most of. Oh, so there was one actually final question, which a little bit off topic, but I still thought was interesting and I wanted to address, which is, and I've heard other people bring up this concern, is whether or not there is an objective for CMS to ultimately get rid of agents and agencies and web brokers, right? And exclusively use their own staff for enrollment. And I don't think, as Renelle shaking her head, right, there's any realistic possibility of it. I mean, the current administration, including Peter Nelson himself, right, has repeatedly, and I have been there in person several occasions where he's done this, right, repeatedly reiterated the importance of agents and brokers to the industry. So I really don't think that they're going to try and replace everybody with their own staff or through the use of AI. I don't think that's going to happen. And, frankly, I don't think they have the staff even now to do everything that they need. So the idea of taking this on top of that doesn't seem practical. And I think it would only further contribute to problems with the viability of the ACA market. All right, so now I'm gonna look over the questions that you guys sent in now and just see if I addressed anything.
While you're looking, I kind of mentioned this, and I'm not sure if you want to comment on it, but the last time I was in Washington, there was a lot of comments about the state exchange part that would allow the EDEs to run the state exchanges, and how those in Washington didn't think that was a good idea because it kind of gave the key to the city to some of the biggest EDEs. So did you have a chance to dive into that, or do you have any thoughts?
I don't have a ton of thoughts on that. I think it's interesting. That's the direction that they want to go in. I don't know. I mean, I think certain states are not gonna do that, right? But I think, Georgia is an example. I wouldn't be surprised that you may see states that kind of transition to using EDE platforms rather than what they use today. And from what I understand, the costs and fees they pay to the companies today that support many of the state exchanges is a lot higher than what companies like Health Sherpa would charge. So, I mean, look, could it be for the best ultimately? I mean, it would be nice to have a world where an agent could go to one platform and enroll everyone in every state. But I mean, I don't like Cover California is an example. I could never see them moving off of their own platform. I mean, it's pretty good. It, I personally like it, and it's been in place for a long time. In other states like New York, right? I can't imagine that they would do that. But it is interesting that they're at least allowing it. So, I mean, we'll see ultimately what happens there. So, going to Stacy Smith's question about the bad actors and if an agent buys a lead from these bad actors, who's at fault? So, CMS can ultimately say that you're still at fault, right? And there's no way to actually say how this is definitively going to pan out. But I think this is where the idea and concept of acting in good faith makes a difference. Like if you have a process and program where you're routinely auditing ads, asking, your vendors for proof of or a copy of the ad that resulted in this call being sent to you or this lead, right? If you're taking those measures, I would like to think, right, that shows that you're engaging in good faith and that you're not intentionally purchasing them or turning a blind eye, right? Turning a blind eye is arguably as bad as the people that do it intentionally. And I think the technical assistant process does kind of show that that might be the direction they're going in because by, the nature of what they're describing, they're giving you the opportunity to take it down. And then after you take it down, ensure that you're using compliant marketing going forward. Because look, as with anything else, right, 100% compliance is impossible. Anybody that tells you that that is possible is lying because you're going to have the human element. And there's always going to be somebody somewhere intentionally nor negligently, right, does something or uses something that's not considered compliant or proper. And ultimately, with the you own your downstream process, they can try and hold you responsible. But, if you terminate those relationships, you specifically ask for these ads not to be used. You have strong contractual protections. I think all of that can help create a defense against those types of investigations. So I hope that makes sense. So Karen had asked the question, uh, if we would need to have to get consent each and every time we do something for the client. So I best practice would be yes, right? And ultimately, it's also possible, and I've seen mention and thoughts of the consent expiring, right? So consent only being good for a year possibly, or for an OEP season, right? I've seen that idea thrown out multiple times. But right now, I mean, technically, the answer, I guess, is no. And under actually existing rules, multiple people can have consent at the same time. So you as a client could technically give consent to multiple different agencies. Now, obviously, when it comes to like the agent of record, it doesn't work that way. But on paper, it's possible. And in their FFM cert this year, they actually said as much, right? So I I don't think that's gonna happen, but I've seen crazier things change from a proposed rule to a final rule. So ultimately, the final rule, I think, will show us what their intent is and whether they want expirations, whether they want every single time. I mean, look, from a compliance perspective, is it bad to get consent every time? It provides a defense. And Renell, I know you've talked about this many times in conversations, right? As it sits today, the consent form is more protection for agents than it is for a customer's benefit. And that's kind of the way to look at it. But look, if you can defend that the consent that you had is valid and still exists during the period of time, as long as the customer knew that you were making those changes and they were authorized, there's nothing that says 100% of the time you'd have to get a new consent form every time.
Right. And I don't think that a new consent form is necessary. I think that we should have consent and you should have an email reporting, text, something saying that person wanted us to do that. But you touched on something very important. Agents and brokers are continuously being charged with fraud. However, consumers can give their information to different people, meaning that in many times they can be the ones that are the end of the problem. They might have given consent to two people or three people, but then that agent gets in trouble for fraud when they really shouldn't have. And that's kind of something that we've been working with our attorneys that we need to make sure that consumers get in trouble when consumers lie and agents get in trouble when agents lie and that everybody is on the same playing field.
Agreed. Agreed. So in looking at the rest of the questions, I think that actually covers pretty much everything. So I don't know if anybody else has any additional questions that you want to shoot it in the chat, or Renell, I mean, if you don't have any objection, somebody wants to talk and ask it that way, happy to answer what in the
Yeah,
last
no,
couple
that's
minutes we
that's
have here.
perfectly fine. If we want to open the floor up for questions,
Sure.
um, amazing. You've got him to help you while we're here. I just want to encourage you to comment. It's not hard. You click comment. You type what you want to type. You can upload a letter if you want, but definitely comment. There's only 50 comments so far, and it's due March 13th. We talked about the other day, Alex. We thought it was the 11th. They changed it from the initial to March 13th.
Okay. All right. Interesting.
You've done so good that they don't even have any questions.
So one question from Michelle. It's a great
Oh, that's a
question,
good
right?
one. Keep
We're
from the
talking
bottom.
about I mean, I think it's entirely possible. I mean, if you think about it practically, why wouldn't they, right? Because they're trying to curb non-compliance. So I think it would actually probably be for the best, personally. And then I guarantee there's plenty of people that don't agree with me. if states were to also do the same thing to help curb, because I think that would help the industry ultimately long term self-regulate, because you have pretty much the entire country saying you cannot engage in this type of conduct. It's not just, certain states, because bad
And
actors can then target that or try
well,
to.
now, when they first came out with the consent, CMS said this applies to FFM and states. And states stepped up and said, not going to do it, not us, we have our own. So that's where you're going to find the rub. And what that looks like, I don't know.
Yeah. Yep. And
And And
go ahead.
Stacey's asking, what do you think she should propose and or what should she fight? And I think that's a very personal thing. Probably Alex and I would disagree about some things. Probably different people on this call, what's important to you? I'm personally against the consent form that they created because there are too many people that already have processes in place. Do they have to meet certain criteria? Absolutely. Do we have to follow the rules? Absolutely. But we've been working under the guise that just do it and create your own. And Hop even created one. It was approved by CMS. I just think that's a little taking it too far. But I don't know if everybody, totally agrees with that. But as Fran said, it is over 500 pages. So it's just, where you come from. Some people are with state exchanges are going to be against, Health Sherpa being able to run all the state exchanges. There's going to be different people that think different, different things. And I encourage you to just Google it. Look for some cliff notes and just talk about agents and brokers or, about what different things that would affect you as a industry. And Alex, I'll let you chime in.
Yeah,
Sorry.
for sure. And look, there are other parts of the rule that we didn't discuss that I do think are really important to keep in mind. Like for example, is the proposal to get rid of standardized plan options like we have today, right? To give carriers more flexibility to have a variety of benefits, so there's, more choice between plans. I know some people that love that idea, and I know other people that don't. And I mean that it really depends like what your position is, and I think also it depends on the communities you serve, where you sell. All of that I think has impacts. But that is a great one, right? It's another example. What else? There was actually one more. And then, the whole piece with the bronze and catastrophic plan restructuring is something that is very interesting. I think is very consistent with the message CMS has repeatedly brought up and Peter Nelson himself has talked about in a few different events that I've been to related to, the importance of making catastrophic plans more available as a viable option and, bronze plans. It, their proposals are interesting. I don't know if they will all go into effect as is, but they are certainly interesting for sure.
What we found out that catastrophic plans are out there, but not every state has them to offer. So that was very interesting that we found out this year. And something I'd like to tell you guys that maybe you've never looked at a proposed rule before, but I find this very intriguing that on the first page, there'll be a whole list of CMS folks that with their phone numbers and, they're the people to talk to about comments. However, if you reach out, they'll say they can't talk to you during comment period, which I think is insane. Why put your name on there? Why say that you're there to answer questions and they won't answer a question? So I think that's ludicrous. That's just my 411 for the day.
And ultimately, look, I generally read every rule top to bottom, right? Whether they're 200 pages or 700 pages. Yeah, I'm also, a legal nerd, right? Like I like that kind of stuff. But there's great summaries online, and even, leveraging AI, right? AI is not going to be accurate 100% of the time. You'll see that disclaimer 100% of the time, right? But it can still give you good information that you might not otherwise have if you aren't comfortable reading the whole rule. Or look, there's definitely elements of it that are very legalese, right? because they have to just by their nature. There's plenty of things that you can do to ultimately leverage it, honestly. It's all about the effort that you really want to take in and put in.
Yeah, just don't be scared. I mean, don't think that you have to be perfect. Don't think that, you have to be right or wrong. It's your right. So I just encourage you to participate.
And ultimately, technically, they are required to read every single comment. It doesn't matter if your comment is 2 sentences or 100 pages. I mean, granted, I don't, hope you would write 100 pages, but regardless, right? They have to read they technically have to read every single one of them.
Absolutely. CMS Medicare just told me that the other day when we had the proposed rule for Medicare. They said, Ronell, we read every page and we encourage you to ask your agents to tell us what you think because we do read it. Now, whether they take it into, you know, their decision-making process, I'm not sure about that, but, we can't read their minds, but they do read it.
Yeah. And their final rules evidence that, right? Because they have pretty much every single section has a piece about what commentators, I can never say that word properly, what people who are commenting actually say, and their response, whether or not they agree, they believe it's valid, all of that. And you also have to remember too, a lot of this, they include what they call it's not really requests for information, but I forget the exact language. I think it's like requests for proposals, where they're throwing an idea out there and they're effectively asking the industry, do you think this would work? Is this something that's feasible? And those are arguably as important to comment on as anything else, because for ones that CMS doesn't really do that and they just say this is what we want to do, you would think that practically they're less flexible and movable on those items. But for items where they're explicitly seeking the input from the industry, I think there's a lot of value in giving feedback there.
So I sincerely appreciate you doing this again for us. On the Monday Morning News, if you're a HOPA member, I will include some different places where you can look up uh, places that kind of give you a general idea of what's going on in the rule. So you can kind of have some talking points and help you write those letters. And as Alex said, ChatGPT is always, not always correct, but it can help you find some things and it can help you write the letter. So if you just say, I want to say these things, if you want to write a professional letter, it'll do that for you. And then of course, if you need a deeper dive, then always, check your legal counsel.
Right. That's a great pointer there. Right. And I didn't say this time around, but I should have. So I have to always give the disclaimer.
Got your
This
disclaimer.
this is not legal advice, right? This entire presentation discussion is strictly for educational purposes, right? And I have the little disclaimer slide in there too. So ultimately, before you act, you always have the right and should consider talking with, a compliance expert at your company or externally, right? Or legal counsel. And there's a lot of great resources. And I don't know, Renell, if we have or we've ever talked about like people we could possibly recommend. I don't know if we've ever considered that, but I mean, if you
Yeah,
look
we
it
do.
up, yeah, there are great
Reach out to
options.
me, absolutely. Not something that we publicly put out, but
Yeah. Okay. I didn't think so. All right.
yeah, I mean, Dicer's Law is one of
Well,
our sponsors. And they are on the call listening and telling me what to say, not really, just texting me silly things. But they are, our platinum sponsor, but we have, other attorneys. If you're looking for somebody in your specific state, we can recommend somebody too.
yep. All right. Well, it
But
doesn't
thank
look,
you
it
so
doesn't
much.
look,
Thank y'all for joining. Have a wonderful day. And remember, March 13th is your deadline.
thanks everybody. Have a great day.
Have a good day.